What about these people at BART? 2 people were murdered on those tracks. Who's going to jail? And if they're not afraid of going to jail and there's just financial penalties, they're not going to change their habits.
The California state law squarely puts the burden of safety on employers. Employers have to provide a safe working environment for their employees.
They do what they want to do, and they're not interested in the union's suggestions, good or bad. It's just their railroad, and they're going to, by God, do what they want to do. And that is the attitude of them, and they don't care who they kill. I know many of these people personally, and they all seem like good guys, and most of them are, but there's somewhere up there of power that has their thumb on, and they just don't care.
Culture at BART that does not take, frankly, workers seriously or the health and safety of workers seriously.
BART officials continue to appeal that decision and reportedly spent as much as $300,000 in legal fees fighting this case. The court case continues to stretch on. It's scheduled for a hearing in January of 2014. The unions are going to be seeking the strongest administrative responses possible, willful, serious, repeat citations for these 2 deaths. And we want OHSA to do the investigation and referral for criminal procedures as well.
Do you think a public agency should be able to appeal decisions of Ca-Osha that they're serious health and safety determinations? Apparently they spent over $300,000 of public money appealing decisions that they had improper health and safety procedures. Do you think that should be allowed under state law?
I believe that public agencies need to do their due diligence in protecting the taxpayers and protecting their workers. I believe that BART can do a better job and has left a little bit to be desired, if not a lot to be desired. And because we've seen the repeating focus or the illumination on the simple approval process. And when you look at the 08 passing, Mr. Rhodes, and then the Strickland passing in 08, simple approval has been the procedure in question, and the procedure held liable for the danger and the cause of death.
Management sent out an email today kind of lauding that they have great procedures in place and that they are very safe. What would you say to that?
I would say that they are erroneous in that statement, and to support that, my position is finally, it was after these most recent deaths that the simple procedure method has now been suspended after many, many years of them contesting that procedure was safe.
$300,000 has been spent by BART appealing a determination of Ca-Osha that there were unsafe working conditions. BART, what's your response to that?
My understanding, when I was briefed about the Ca-Osha matter, was it wasn't an appeal against, bad safety things, etc. It was more a concern about how it was classified.
But those were determinations of Ca-Osha that there were violations of health and safety process. That's being appealed by BART. Do you support that appeal?
I support what BART has told me, which is not that.
But they spent $300,000 in public funds.
Correct, and I was one of the board members who authorized that.
So you support that, appealing the determinations of Ca-Osha?
I do.
Well, on what basis do you support that appeal?
Because the appeal is based on, it's very complicated to articulate here. It's based on accusations, not the underwriting facts.
Well, why have they changed their policies then?
Why we just did change our policies on the simple approval.
So why aren't you dropping the appeal?
We are not dropping the appeal because of the accusatory claims involved with it.
Who do you think is responsible for the deaths of those 2 workers?
That is to be determined. We're having that objectively evaluated by the NTSB.
Do you think it was a mistake to try to train people, untrained people on BART during the strike?
I believe that our contract allows us to train workers after once the contract expires, we're allowed to train workers.
You support that decision?
I don't have any immediate opposition to it.
So you supported the training of untrained people to run BART when they were on strike?
They were not untrained. Okay.
There
were trained operators there who were training others to become certified.
But there was no certified person in the cab.
Yes, there was. There were certified people in the cab and immediately outside training the trainees.
That's not what the NTSC said.
That's what I have heard.
So you think that it's proper, your procedures, and so you support that?
I supported the training of trainees with the trained operators, yeah.
A bit of exception with the NTSB's report that they provided to you, saying that the person that was operating the train was a trainee, being trained by someone that is not in our bargaining unit, because we have 6 classifications. One of those classifications, who you'll hear from later during public comment, is the Employee Development Specialist. Their job provides training to station agents, to our forwarders, which are our first-line managers that operate the movement of the trains, and our station agents. The person on that train was not a member of our local. We were on strike. The person training that person was not a member of our local. So I take a little bit of an exception with them saying those are train operator trainees. In fact, they were not.
About the death of James Strickland, what were the lessons from that death?
I wasn't around at that time. I can't provide an informed response to that.
Well, Ca-Osha said there were serious health and safety violations after that death that are now being appealed by BART.
Okay.
Yeah, so what's your thoughts on that?
And again, what I've been told by BART is what we're appealing is not the underlying facts surrounding it, but the accusatories surrounding it.
Now, you issued a statement to your constituents in which you attacked the BART workers, their demands and their wages, and this deal that was proposed. In your statement, there was no mention of the deaths of the 2 workers. Is there any reason that you did not mention those deaths?
Because I do not view it as related to the strike. I view it as an isolated matter surrounding our simple approval process.
So those deaths would have taken place regardless if there's a strike or not?
It's hard to say. I don't view the strike and that as intrinsically related.
Don't you think that the deaths had something to do with the strike?
I'm not inclined to support that claim, no.
That they would have been working there like that without a strike? Is that what you're saying?
The simple approval could have and likely would have been granted.
So they would have been training these people even if there was not a strike?
Yes, these operators were in training long before the strike. They were not brought in at the time that the strike happened. They were continuing their training.
So this was a regular operator that was being trained to take jobs?
A regular operator was training new trainees who entered their training course before the strike.
So these were new hires to train? Is that what you're saying?
These were new hires who were getting trained, and they began their training before the strike.
So the guy that was running the train was being trained to run on a regular basis the trains. He wasn't a special worker that was brought in to replace the workers.
There were, I think, 5 or so workers. I forget the exact number, some of which were trainees, others were trainers, experienced operators.
So as far as you're concerned, that was a good process?
I don't see anything that I would oppose to with it.
BART's general manager came to the accident scene and expressed condolences to their families.
Our hearts and prayers go out to the families of 2 workers who've just been killed on the BART tracks.
This is a tragedy of the greatest proportion for the BART family.
Assistant BART manager Paul Overseer said the train was in automatic mode and that an experienced train operator was behind the controls. But some union members claimed the operator was a manager without recent experience, filling in for operators who are now on strike.
If that was a experienced train operator, it wouldn't happen.
It's an allegation BART officials would not discuss.
We've just lost 2 people in the BART family.
Investigators have not shared many details about who was behind the controls. A train operator who is on strike says he's been through a similar investigation after someone jumped in front of his train and committed suicide last year.
When you are involved in a fatality, you have to have a drug test. There's a camera in the cab. They want your phone records.
NTSB investigators have already secured video recorded on board, and they'll interview the train operator sometime Monday.
When you have a high-speed train going down where people are on the tracks on automatic pilot, when the protocol says you should be going 25 miles an hour on manual, something's wrong out there.
In most cases, I think the district has acted in good faith over that lengthy period to try to abate whatever the citation was based on.
All open safety notices are reviewed and tracked until they are completed and closed.
On the committee that we're talking about 45 citations over a 12-year period. And so I agree with my colleague. I don't have the specifics either, and I've been here that whole time. But I do agree with my colleague that in most cases, I think the district has acted in good faith over that lengthy period to try to abate whatever the citation was based on. I would also say, and this is by no means a criticism of Ca-Osha, but the BART experience with the Ca-Osha process is that the investigation doesn't really start until you appeal. And so that's why we appeal, and frankly, again, very respectfully, I think the proof is in the pudding. When you look at the initial citations compared to what the final agreed upon settlement was, you find that we paid something like 22% of what the initial citation amounts were, or the initial fine amounts were. And we think that's because, as I said, the real investigation doesn't start, in many cases at least, until there's an appeal filed. That starts the dialogue going between the district staff and the professional staff at Ca-Osha. I really can't answer that question.
I don't think it's that technical a legal question. It's something that attorneys would consult their clients on. Is there a hearing? Why would you intend to defend the simple approval process or not, or are you saying you don't know?
I can't answer the question.
Just to help clarify the question a little bit, you're part of leadership for BART,
yes.
Correct?
Yes.
You're part of leadership. All right, so we all send leadership positions, and we all send lawyers to meetings. But the leadership gives direction to those lawyers.
Right.
So your leadership team, is a direction to attorneys, is it to defend the position or not?
Well, it would be to defend the position as it existed in 2008, but the statement that I made to you today, that we are no longer utilizing simple approvals, deals with where we are in 2013. That was the reason for hesitation, because the citation is based on something that occurred in 2008.
You've come before our committee without any specific response or any detailed information. It's extraordinarily disappointing.
Are you concerned about the number of inspectors in Ca-Osha? There are only 260 inspectors in California for 17 million workers in
That's
California?
concerning. There isn't enough. We need more.
Why hasn't Governor Brown spent the money that's been appropriated for inspectors in California for Ca-Osha?
I don't think the decision has solely rested on Brown's shoulders. I think that there are people at the agency level that could better manage and appropriate those dollars.
My name is Michael Patchen. I'm a train operator, employee development specialist, which is a fancy way of saying I train operators. The course of my duties is making sure that BART and the trainees that we follow the BART certification plan, which we give to the BART PUC. There's very specific rules that are in this plan about how testing is done, how much training we give to all the trainees, etc. A normal training class takes 14 to 16 weeks, and I'm also in charge of making sure that train operators are retrained every year and a half. So what happened on October 19th, we heard a lot about simple approval, and while that is a flawed system, that isn't the cause of this problem. The cause of these deaths, we're having untrained people out there. Untrained people who were there in a situation that was very, very dangerous. Normally we use simple approval because of expediency. We don't want to delay traffic. Well, there was no trains going on at that time. There were no passengers on board. They could have easily had work orders. But why did they not have work orders? Because they were untrained. People, imagine you went to an airport and you were going to get a ticket, and they said, well, the pilot, he isn't certified anymore. He was certified about 10 years ago, but he knows what he's doing. And then you said, well, maybe I'll do that. Oh, by the way, actually, he's not the one operating. He trained himself how how to retrain people, and he has a trainee in the seat who's never operated. How confident would you feel about being on that train? And oh, by the way, the air traffic controller is another trainee who hasn't done this. That was the situation that was going on at the time. We had people who, the recertification process they gave themselves, it was a person who was not certified, recertified themselves, and then, even though they'd never been a trainer, felt that it was okay to go on and train other people. I know a lot of these people who are involved in the training process because that's my job. So I know some of these middle managers, and they all came to me afterwards and said, you know, off the record, you know, we all knew this was a bad idea. It was a horrible idea. And they were all saying that to me. And the question comes, well, why did you do it? Why did it happen? Well, the reason is because clearly upper management came to them and said, we would like a training program. We would like to train people in the event of the strike. Not we would like a safe training program, but we would like a training program. And these middle managers, none of them felt confident to go up and say, you know, that's a really stupid and dangerous idea. Why? Because, again, the culture we were talking about. Nobody here feels, from middle management, feels like they can question a dangerous and stupid idea. And that's what cost those two men their lives.
My name is Charles Miinster. I'm a member of the Senior and Disability Action and the California Alliance for Retired Americans. You know, I would stand here and accuse Mr. Overseer and the BART management of murder. And Mr. Overseer said he worked at New York City Transit. Well, in 1912 in New York City Transit, there was a motorman strike, the subway system. And management decided to run the subway system with scabs. And they had an accident on the system that killed 112 people. That reverberated throughout the East Coast. And they don't run scab trains during a strike on the East Coast. But he thought he could do it out here, because that's basically what he was trying to do, train these people who were not trained. They had these 14 weeks. An operator has to be trained. They were going to do it in a couple days. He sat here for 15 minutes and defended simple approval, which we know killed 4 people already. So this guy and the management of BART is definitely a murderous crew. If they were really concerned about safety, I'm always concerned when I'm on a train, and Sister Bryant here mentioned it. She's a station agent, and somebody gets sick down there on the platform or on the train. She's got to run from the station down to help this person. If you're a train operator on a 10-car train and something happens to the door of another 9 car, you've got to get off of that train and go all the way back to the 9th car to fix that problem, if you can't. Now, it would seem simple to me, and certainly of use to us as patrons on this system, to have a conductor on all trains, as the New York subway system used to have until management decided it was too expensive. That person, that conductor, would be giving information like they used to do in the New York system to people that are visiting, don't know how to get to operate in the system. And also, in case someone gets hurt or there's an emergency on the train, that conductor can do something on the train to alleviate the problem while the driver remains in his position. But this management could care less about that. They're concerned, and they operate like a private enterprise. They're looking at the bottom line, and that's their only concern. And it's caused these 2 deaths, and it would have caused a lot more. We might be thankful for those deaths, because if they'd been running scab trains, we might have had people killed on the line in the passenger side.
I'm Christine Baker, the Director of the Department of Industrial Relations, and I'm here with Juliann Sum, Acting Chief of the Division of Occupational Safety and Health, or DOSH, within the Department of Industrial Relations. Our Ca-Osha investigation found that the area where Mr. Strickland was working was covered in overgrown shrubbery and minimal space to safely walk while doing his job. He was assessing the track under the simple approval procedure where workers were responsible for protecting themselves by being watchful, vigilant, and ready to exit the track quickly. At the conclusion of the investigation, DOSH issued 4. BART challenged all of the citations through administrative appeals. On appeal, an administrative law judge with the Occupational Safety and Health Appeals Board sustained 3 of the 4 citations. On reconsideration, the board affirmed the classifications of 2 of the 3 citations as serious accident related and remanded or returned the case to the administrative law judge to determine whether the classifications of these 2 citations should be amended to willful. The classifications of serious, accident-related, and willful serve to increase penalties compared to general violations. One of the citations, number 4, was directly related to BART's use of the simple approval procedure. On remand, the administrative law judge reclassified the 2 citations as willful. The board denied BART's petition for reconsideration of the administrative law judge's decision after remand. On July 26, 2013, BART filed a lawsuit called a Petition for Writ of Administrative Mandamus, challenging the board's decision in Alameda Superior Court. That case is still pending. Of our processes, regulatory processes that would make it actually much more effective.
Okay. Thank you for that. I appreciate that. And if you're interested in the bill, I'm interested in that bill. And my understanding is that it would have required employers to abate hazardous conditions during an appeal if the condition put workers at risk of death or serious injury. Would any of the 4 citations that you referenced earlier have qualified as conditions that put workers at risk of death or serious injury?
Most likely, one or more of those citations would have fallen in that category. The issue with that bill is, in addition to having that requirement on employers, it provided for an appeal process on that, which potentially could have slowed the overall process. So it would have been an appeal process before the Division of Occupational Safety and Health, not before the appeals board, on that requirement to abate. I mean, they could have requested a stay of that in the litigation process.
Were either of the 01 or 08 fatalities forward for consideration for criminal prosecution? If you can answer the first part first.
The decision on whether a case is referred for possible criminal prosecution is made after an investigation by the Bureau of Investigations within our division. And they would go through, they do an investigation to look at whether the elements of the crime potentially will be legal in a prosecution, a criminal prosecution proceeding.
They are referred after every death.
Yeah. And
if
so
there is a death, it does go over to the Bureau of Investigation.
All fatality cases are automatically investigated by the Bureau of Investigations, and then certain other additional cases are referred to depending on what my staff find in their administrative investigation in the citation process. So that some of those also get quickly referred to BOI to determine whether the elements of a crime would be there in that, causing that injury.
And the reason I asked, to be quite frank, is when I read the probable cause statements for the 01 fatality and the 08 fatality, I saw their statement that really kind of put the attention on employee error, and I didn't see anything speaking to a lack of proper safety measures on behalf of the employer. I didn't see anything that pointed to liability on behalf of the employer. But when agencies that are monitoring and investigating, the kind of the common current light was that there was issues with the simple approval process. So the simple approval process that comes from governance, that comes from administration, they direct and govern over these procedures, because it wasn't the workers that removed most recently that procedure, it was administration that removed these procedures. So I'm wondering why there wasn't a finger pointed in that direction there in the 08 findings and the 01 findings.
I don't know specifically about the findings for those cases, but I do know generally that for a criminal proceeding you have a higher level of proof. Beyond a reasonable doubt, you have to look at the intent of the culpable parties, whereas in an administrative action, you don't have that high level of proof, so you could hit that threshold first and find liability for a citation, but not quite reach the threshold for finding criminal liability. That they knew that it was likely to cause, an injury, and if kind of like reckless disregard or something very close to direct intent.
These are really factual case-by-case evaluations, and it's hard to generalize. It really is the individual facts of that particular case.
The Bureau of Investigations, which is within OHSA, as we said, will review each fatality, case-by-case basis, to determine whether it's likely. Send it to the DA. Some cases that have resulted in criminal prosecution are where the DA has found that the company intentionally took the act. It's not so much that they intentionally meant to harm somebody, but they intentionally took the act that led to the fatality. So we've had, for example, several roofing cases where an employer intentionally allowed workers to work without fall protection or other safety, where they knew that that it was required. And it's slightly different the way that the criminal prosecution looks at it, and they can prosecute directly under the Labor Code, 6324 and 6325. So it's not the same standard that's utilized in your traditional criminal case. It is its own standard under the Labor Code that they prosecute. And they look individually at the case to see if the employer intentionally took the act. So that's a good and easily understood example of not providing fall protection.
Thank you very much. Sure. Appreciate it, Mark. And Director, in the second part of the question, maybe you might have answered it, but you weren't sure. In the 01 fatality and the 08 fatality, were either of those incidents moved towards prosecution or recommended for prosecution, criminal prosecution?
They were not. They were both reviewed, but they were not referred to a district attorney.
OHSA Chief Counsel, and what Juliann was trying to say was inaccurate. You don't need to have the kind of intent that they were hoping to describe to bring a criminal case. We've been doing criminal prosecutions in OHSA for a while. The law was changed in order to make it absolutely clear that intent doesn't require a violation of law. It doesn't require you to intend to injure somebody. It doesn't require you to get some benefit as a result. We have at least 2 sections. One's a misdemeanor, one's a felony. Labor Code 6423 and 25. We also have manslaughter provisions that can be used. And I think that this case deserves to have an investigation. And I think that Ca-Osha will do it. What I would ask the legislature to take a look at is the code section that sets up the Bureau of Investigations and says what they're supposed to be doing. Because you just heard from another witness that these kinds of patterns have happened before. You find a fence that's not being erected, they put up a fence, but they don't go and look at the other places. So basically, criminal penalties and more, I mean, you're not going to ever get it with your fines because they're completely inadequate. But the criminal penalties, the threat of criminal penalties can make a difference, and it can't just be limited to fatalities. And that's what the Bureau is limited to at this point, unless they get a referral. It needs to be broadened so that you look at these kinds of repeat situations and get that under control.
I've been in transportation since 1990. I'm speaking as a ATU 1555 rank and file member, train operator, and a 50-year citizen in this great state. First, I'd like to say at the October BART Board of Directors meeting, I reminded them and warned the board and management of making sure to follow their own operation rules and procedures, which is their fiduciary duty to provide safe and reliable transportation. When I got hired at BART, I was handed this. My instructor told me that some of these rules are written in blood in this book. Don't let a rule be written for you. I am saddened by the fact that due to BART's blatant negligence of its own operation rules and procedure manual, that we are here today to review the tragic and preventable killing of 2 people. For me personally, I haven't been able to sleep through the night. It was senseless, and demonstrated that the BART Board of Directors' blatant disregard for human life, the workers, and negligence in fulfilling its fiduciary duties to ensure safe and reliable transportation for the traveling public and its workers. Specifically, in the Rules ORMP, Section 1, General 1101, it states, the rules contained in this book apply to all district employees and contractors. 1108, violations of operational rules must be reported to the supervisor as soon as practicable. Section 1 states under operations, 1403, personnel shall not operate trains, vehicles, or other equipment unless qualified or authorized to do so. Now this is their own rules. And it's my belief if they would have just followed their own rules, we wouldn't be here today. And I just find it almost the arrogance of saying, well, anyway, let me go. So I do have a question. One of the questions that we need to ask them is, was there a certified train operator or an EDS, Employment Development Specialist, or a train operator on board authorized to do the training on the train that caused a tragic and fatal accident? My second question, would you confirm in addition to the 2 people being killed that day, earlier that same day was there another collision? And then BART management continues to put workers at risk by asking them to do things out of classification like remove cover boards from third rails presently today. And then this BART Board of Directors and General Manager need to be held accountable for their actions and blatant disregard of their own operation rules and procedures to ensure safe and reliable transit. And there's also one part in here that lets me know as an employee, because I'm responsible for the people on my train, that we always take the safest route possible when in doubt. So when I hear, oh, well, you know, it's about the scheduling and it's time for them to take responsibility for their arrogance and blatant disregard for everyone. It's here in their book. I'm sure they're employees just like I am, or contractors. So thank you very much. I appreciate you guys taking the time and having the integrity to get to the bottom of this. Because it's been happening too long, and maybe somebody needs to be held accountable, and then maybe they'll start taking safety seriously.
It's only when the death of a worker costs many more times more than the cost of the unworking or unsafe working conditions that change is forced upon an industrial entity. BART's management, with the help of the safety department, have a Dorian-Gray painting on the wall of the ivory tower when it comes to safety. A safety culture does not exist at BART. What does exist is a culture of cutting corners to speed up work and reward those who get it done with an absolute minimum of time lost in implementing safety measures. This was contributing cause in the Lagsman accident occurring in 2003 when a BART electrician came into contact with 34,500 volts. It was a contributing factor in the Robert Rhodes death in 2001. He wasn't trained to be there. That was his 4th day working in the tunnel, and was a contributing factor in the James Strickland accidental death in 2008. And it was also a contributing factor in this recent one at Walnut Creek that we've been talking about. BART relies on the less protective safety measures and policies like the simple approval, which proved fatal in at least 3 instances that we've been talking about. A future accident looming on the horizon will be due to BART's use of the power off for high voltage protection rather than the traditional safe clearance for electrical voltage protection for the safety of the workers. During my tenure as chairman for the safety committee and 3 years as the BART chapter vice president, I conducted many investigations of complaints for our members on unsafe policies and procedures and actions that resulted in some 33 or so citations against BART. BART chose to appeal almost all of the citations and lost most of those cases and evaded unsafe conditions anyway. This is not a product of a safety culture. As a safety chairperson and vice president, I attended hundreds of meetings with BART management, maybe the thousands, in which the goal of the meeting was to get the union leadership to go along with shortcutting safety to get more work done in less time with less people. Very few exceptions, very few people that will tell them I refuse, because then you have to face your boss back at the shop.
BART electrician trainer and temporary trackway safety trainer. Simple approval authorization implies an attitude. On-time train performance is more important than wayside worker safety. Stay out of the way. The radio read back to BART Central includes the words, provide your own protection, do not interfere with mainline or yard operations, expect train movement on any track, any direction, any time. Without perfect situational awareness and experience, wayside workers are at risk. I want to make a few points on safety issues at BART. Training. All stakeholders must be involved in the internal rulemaking process, but most of all, the people out there wayside who do the work next to the trains. Their input, their ideas, their experiences. We've been cut out before. Second, we need training that gives wayside workers real-world experiences, like the Oakland Y Underground tours, which are now prohibited by the suspension of the simple approval, and low-speed train operating areas. This is a controlled environment with experienced people showing new people the dangers. This is a major advancement over classroom training, and I hope it can continue. We need open channels of communication between wayside worker trainers and operations control center trainers. I started a dialogue about electrical safe clearances via phone and email with Dennis Ackman, the power support controller trainer who spoke earlier, but was told by a senior operations control center manager that all further communications with Dennis would need to be cleared through him. Culture of safety, I see a culture of secrecy, of compartmentalization, of you don't need to know. We need to make training and safety an integral part of BART, not some sort of regulatory burden having a minimal response and resources. I would welcome any new technologies that would improve wayside worker safety. These include vehicle detection technologies using magnetic field sensors, GPS, and positive train control. The Robert Rhodes 2001 incident at the underground interlocking near 24th and Mission Street stations shows a need for improved subway lighting and safe passage walkways totally clear of track, whether in underground or on aerial structures.
15 seconds.
Thanks. So we trainers do our best to develop our co-workers' accident avoidance, but if there are technology structural retrofits or wayside safety rule changes that can improve worker safety, we have to do them.